Following the Gwyneth Paltrow ski crash trial, the 50-year-old actress is being sued for supposedly crashing into her fellow skier Terry Sanderson. Paltrow claims that it was Sanderson who ran into her on the Deer Valley Resort ski slope back in 2016 and is countersuing. For now, let's head back to the Utah courtroom and continue listening to testimony in that courtroom right now.
In this case, actually, I don't remember if it was multiple years, but it was a while back. June 21, 2021 is what I have.
Correct. That's correct.
Oh, okay, great. Okay, so I'm glad you have that with you. I have the exhibits to that, and I can pull those up if we need them.
Under that.
Okay, so let's start, though, with just some couple quick follow-up questions on your background and training experience. So one of them is just, has a court ever excluded your testimony from trial?
Not from trial, no. I mean, I had a motion of limine that we were going to have an evidentiary hearing on, but the case settled right after that, so we never had the evidentiary hearing.
Okay.
And that's all I'm aware of.
Okay. And then this is just a quick question about billing. We don't have to spend much time on it. I have
Sure.
your fee schedule, which is the document that describes what you charge for your work in this case. And you charge varying things for an exam or a deposition,
right.
Records review. But can you give me a sense of how much you've charged the plaintiffs to this point?
I think I've only charged my retainer, which was $4,000 a few years back. Now, I am charging $5,000 for the preparation and the testimony today. So that I have. Now, I don't know if I received that $5,000 yet. My administrator would know that, but I would expect that I've received $9,000 today.
Thank you. And then what about time spent? Do you know how many hours you've spent working on the case?
No, I just jot that down, and my rate changed last year. So before, when I was hired on this case, I was only charging like $400 an hour. So I would imagine I've spent clearly 10 to 15 hours for sure on this matter.
Okay. Thank you.
You're welcome.
Okay. Have you ever worked as a biomechanics expert in snow sports science?
Snow sports science?
Yes.
No, no one's made themselves out as a snow sports science institution that actually hired me on something, but no.
Okay.
I would have to say no to that.
Okay. And speaking of such institutions, do you belong to any organizations that do work specifically in snow sports science?
No, I'm a member of the American Academy of Neurology, the Biomedical Engineering Society, and the Society of Automotive Engineers only.
I see. And have you ever performed research that focuses specifically on biomechanics as applied in snow sports like skiing?
No.
Oh, okay.
I don't design skis.
Right. Okay. And I just want to make sure I understand the way you see your role in this case. At your deposition in 2021, you told me that, and I'll use your term, the main thrust of your testimony would be your biomechanics opinions. Do you remember that?
Or biomedical engineering opinions. Yes, I feel that way now.
Okay, great. So the term biomechanics, let's make sure we understand it because it's not one, at least, that I use all the time. You just clarified it. When we're talking about your biomechanics opinions, we're talking about biomedical engineering. Is that right?
Right. Biomechanics falls under biomedical engineering. Okay, so just get that straight. And it, like I said, is a very wide range field. And people are doing all kinds of research in all different aspects of the field. So biomechanics keep in mind that biomechanical engineers tend to deal with inanimate objects for the most part, whereas biomedical engineers tend to deal with not only inanimate objects, but also with human.
Right, a human subject. Okay. So as you just said to me, you see your role as providing mainly those biomedical engineering.
I mean, the medical records gives us the diagnoses. I mean, his rib fractures have healed up. I mean, we know that. But he has this persistent concussive symptoms that we see throughout the medical records. My job wasn't to treat and diagnose him and come up with a treatment paradigm. My job was to determine how that happened. And I think I've pretty much put that out with obviously the information that I had available to come up with my opinions.
Right. And so I think you've already said this earlier in your testimony today, in terms of the neurological symptoms and the neuropsychological evaluations, you're happy to defer to the treaters in Mr. Sanderson's case.
Well, they're the ones that made the diagnosis. And so I find that after evaluating the patient, his history is consistent with medical records from which the diagnoses were made. So I'm not going to refute that he has a mild traumatic brain injury due to a persisting concussive symptomatology or the fact that he had fractured ribs in the past that have since healed up. I'm not going to refute that at all. I would say that it is consistent with that. To me, the main thrust was, well, how did all that happen?
Right. And in terms of what does he need for treatment in the future, or whether his symptoms will persist in any degree in the future, you don't have opinions about that.
Objection. Compound.
I defer.
Yeah.
I'm just going to make a general statement. I defer all future medical care and the costs thereof associated with that care to his treaters. So I have no opinions on his future medical care needs, nor do I have any opinions regarding the functionality, i.e. what he can and cannot do as a result of his diagnoses seen in the medical records, which I concur with. So I defer that to others.
Right, right. And how his symptoms will continue into the future, what the nature of them will be, that kind of thing.
That is correct. I mean, I defer that to his treaters or the overall long-term prognosis of his symptoms. So
right.
Once again, I defer all of that to his treaters.
Okay. Another thing that I think you made clear in your deposition to me in 2021 that I just want to make clear here today is that you don't have any opinions about whether anyone was skiing unreasonably and caused the collision, correct?
Absolutely. I have no comments on how people were skiing, the density of the skiers, or how that they were conducting business that day, the day of the accident. No.
Right.
It boils down to how, from an engineering standpoint or a biomedical engineering standpoint, how did he develop the symptoms that he has? That's reflected in the medical records.
Right. So in other words, you have opinions about the mechanics of the collision, but not who should be responsible for it.
I have no liability opinions in this matter.
So the answer to my question is yes. Is that
That
right?
is correct. I'm not pointing the finger. I'm just pointing to Newton's 3 laws of physics and the engineering calculations that are consistent, that give you the plausibility opinions that the fall in fact caused the clinical symptoms that Mr. Sanderson had.
Got it. Okay, and at the end of that 2021 deposition, you told me I've provided the opinions that I plan to provide at trial. Do you remember that?
Yes.
And as I hear it today, you haven't provided any new opinions that are in addition to what you provided during that deposition testimony, correct?
That is correct. I mean, and I read through, fortunately, I was provided my deposition just 2 days ago, so I read through it. And the last part of it, you did ask, were there any other opinions? And I said no. And we covered it.
Okay. And you, at that time, when you provided those opinions, you'd said that you did not feel like you were missing any material that you needed to come to a confident conclusion. Is that right?
For my opinions only. Okay. Right. When you just consider my opinions, I had the necessary data that I needed. Now,
right.
If there's some other extenuating circumstance, i.e., he fell off the chairlift before all this happened, 20 feet to the ground, I would like to know that. And so, but I have no history of that. So unless there is some significant departure of the information that is provided to me, my opinions still stand true today as they did back in 2021.
Right. And in fact, in the deposition, you told me that you would let me know through plaintiff's counsel if you came across new information that affected your opinions, and you did not find such information.
I did that. That is correct. That is correct.
Okay. Okay, I think you made this clear, but again, we're talking in a sort of strange way here to a jury that's not present.
Okay, so that's cross-examination of the neurologist who was testifying as a plaintiff's expert witness. Let's bring in my guest to talk about this a little. I have Casey Early, who's still with me, and also Catherine Lizardo joining me. Catherine, I want to bring you in and get your opinion. Thanks for joining us here at Law and Crime today. We've been hearing expert testimony in this case, and this is a neurologist who is testifying for the plaintiff and undergoing cross-examination there by the defense counsel. I want to get your take on his testimony and the importance of it, and what are some of the things that they are looking to draw out on cross, this defense team?
I was actually very surprised with that testimony that we just heard earlier, because I want to point out something very important distinction, which is he is a neurologist, but he just admitted during cross that he's actually retained as an expert for biomechanics. Now, those are two different things. He's a neurologist, but he's using his expertise to determine whether or not the fall that Sanders had caused his injury. So he's not testifying, giving expert opinion as to whether or not he has mild traumatic brain injury, what his symptoms are, or his future care. He clarified that. And that's key, because during the direct, the plaintiff's counsel was asking him questions about mild traumatic brain injury, making it sound like he's the one who diagnosed him. And with his neurologist title, that could confuse the jury, because biomechanics is limited to saying how he got the symptoms. And he said it's the fall, but it doesn't say that Paltrow was the one who caused those symptoms or who caused that fall. There's a big distinction that needs to be emphasized here.
Yeah, and that's one way to attack an opposing party's expert witness, is to call into question their qualifications and what they can actually testify to as an expert, and box them in and limit their testimony in that way. We're going to take a quick break here in Law and Crime. When we come back, more of the GWYNETH Paltrow trial out of Utah, so you want to stay tuned.
I'm Jesse Weber, and you're watching Law and Crime.